morning again. Thank you for being with us. With us for this part of our making the movement toward a level playing field program today is Brad Snyder, the Anne Fleming Research Professor at Georgetown Law School. Brad teaches constitutional law, constitutional history, and sports law. Prior to teaching, Brad worked as an associate at Williams & Connolly and wrote 2 critically acclaimed books about baseball, including the subject of what we're going to talk about today, A Well-Paid Slave, Curt Flood's Fight for Free Agency in Professional Sports. He is a graduate of Duke University and Yale Law School, and he clerked for the Honorable Dorothy W. Nelson on the U.S. Court of Appeals for the Ninth Circuit. He is the author of the recently published book, Democratic Justice, Felix Frankfurter, the Supreme Court, and the Making of the Liberal Establishment. Before we have Brad start with his wonderful presentation and discussion, we have a short video that we are going to play as a little bit of orientation for our discussion.
The legality of Major League Baseball's controversial reserve clause is now in the hands of the Supreme Court. The case involves the trade of Curt Flood from St. Louis to Philadelphia. That case for Flood is being argued.
It was so difficult for the fans to understand my problems with baseball.
Also today,
I was telling my story to deaf ears because I was telling my story to a person who would give their firstborn child to be doing what I was doing, and he just could not understand how there could be anything possibly wrong with baseball.
For nearly 3 years, Curt Flood had been in the courts, fighting a one-man battle with Major League Baseball over the reserve clause. Despite the advice of the Players' Union, he had left the game in 1969 rather than be traded against his will.
What I told him was that I agreed with him in principle, but that the courts had treated players as property and would likely do so again, and that his attempt, while a principled one, was, I thought, doomed to failure. And I worried about his knowing the kinds of chances he was taking, that he was going to end his career in a case that probably was a loser.
the lawyers for the major leagues would not talk for the cameras, but in the courtroom they argued that the reserve clause is essential to the future of organized baseball, that without the reserve clause, all the rich teams would get all the star players. But Arthur Goldberg maintains that the reserve clause, tying a player to one team for the rest of his life, is in violation of the 13th Amendment. That's the amendment against slavery and indentured servitude.
Flood's first trial had been in federal district court in Manhattan in 1970.
I think Curt Flood on the stand was treated miserably by the federal judge. He almost taunted him. A judge who showed great respect for almost all witnesses who were white. From the bench, the judge asked Curt Flood, this is not as easy as playing center field, is it? You know, with a sarcastic tone in the middle of a difficult cross-examination.
No active player dared testify on his behalf. Only owner Bill Veeck and a handful of retired stars came to Flood's defense.
Jackie Robinson walked into the courtroom and there was a hush. He had such a presence that you could hear a pin drop. His hair was white and he was walking with a cane, but he still had that swagger that Jackie Robinson was so noted for. But he testified in my behalf and with a soliloquy that would send chills up and down my spine.
Flood lost in district court and then lost again in the Court of Appeals. And on June 18, 1972, by a vote of 5-3, the United States Supreme Court ruled against him. Baseball was still exempt from antitrust laws, and the reserve clause still stood.
I am particularly pleased that the court has recognized the need for a reserve system and has further recognized that baseball has not disregarded the extremely important position the player occupies. Over the long history of baseball, the reserve system has constantly evolved to improve the position of the player. I am confident that this process will continue.
We lost because my guys, my colleagues, didn't stand up with me. And I can't make any excuse for them. Had we shown any amount of solidarity, if the superstars had stood up and said, "We're with Curt Flood," if the superstars had walked into the courtroom in New York and made their presence known, I think that the owners would have gotten the message very clearly and given me a chance to win that.
Curt Flood never played Major League Baseball again.
Brad Snyder, author extraordinaire, a well-paid slave, Curt Flood's fight for free agency in professional sports. And I've had the pleasure of listening to you speak in the Supreme Court when the Supreme Court paused to re-argue the case in a mock trial format a few years ago, which then led to me getting your book autographed, which I appreciated. And I'm so thrilled that you could join us today on the 50th anniversary of Flood versus Kuhn. And I know there have been other commemorations, but I'm delighted you could take the time today to pause and to share a little bit about that. So I want to thank you, Brad, so much for that. And for those who are watching the camera, Brad was also kind enough last night to be interviewed about his current book on Felix Frankfurter, which has been critically acclaimed by the New York Times and the Wall Street Journal, and that's on YouTube, or soon to be on YouTube. So thank you for all of that. You're a rock star, and but we're here to talk about baseball. We're here to talk about the Curt Flood experience and sort of the current state of what is really a constitutional law aberration where organized baseball, Major League Baseball, still enjoys an exemption from antitrust when other professions, call it basketball, football, are not. Unbelievable, but here we are. So I'm going to turn it over to you, Brad. I know you have a little bit of a presentation, and then we'll pick up some Q&A thereafter. So thank you. Hey, Brad, check your mic. I think it's...
I'm muted, sorry. Can you hear me now?
No, good, yep.
I'm a little worse for wear this morning, but, I hope you'll... and I wish I could have been there in person. I saw the photos of Robert Jackson arguing at Nuremberg behind the podium, and I wish I could have been standing there. I would have been honored to be there in person. I have a household with the flu, but I'm totally willing to go today as long as I've got tea here. I'm good to go. So I just sound bad. So I apologize for that, and I apologize for not being there in person. It's really that Ken Burns documentary is really important. I thought went a long way to showing a wide audience who Curt was, what his lawsuit was about, and also just how smart he was, right? How intellectual he was, and just what a deep thinker he was. It's amazing that kind of 5-minute clip. There are parts of that 5-minute clip I would quibble with, because you have to compress things. But just Curt himself narrating his own story and telling his own story, there was so much power there, and I feel like the Ken Burns documentary, as I'll get to at the end, went a really long way to rehabilitating Curt's reputation, and it was really kind of a high water mark in Curt's post-baseball career. So I'm glad he got the public recognition that went along with that documentary, and I'm really grateful to Ken Burns for doing it. So why don't I start my presentation?
Sure,
How about
absolutely,
that?
if you would, please.
All right, I'm going to try to share my screen. I'm not great at all this. If this doesn't work, can you see my slideshow?
Yes.
Great. All right. So I just want to sort of back up a second and try to give people a sense who weren't alive at the time, and I would put myself in that category. I had little idea when I started when I was a young sports writer in Baltimore, just how good of a ball player Kurt was, and I think that gets a little lost in all of the discussions about lawsuits and exemptions. And for those of you who weren't alive then, or who weren't following baseball in the 1960s, Kurt Flood was the longest tenured member of the St. Louis Cardinals when he was traded. The Cardinals were a juggernaut. He was a 7-time Gold Glove winner. He was a 3-time All-Star on teams that, the Cardinals won the World Series in '64 and '67. They lost in 1968 in part because Kurt dropped a fly ball late in Game 7. But Kurt was on the cover of Sports Illustrated. You may chalk that up to the Sports Illustrated jinx in 1968 as baseball's best center fielder. That's what the tagline said. There's a picture of Kurt in Wrigley Field going high up against the wall to rob someone of a home run or an extra base hit. And Kurt was really good. I mean, I guess people from my generation who watched baseball in the 80s and 90s, I'd really analogize him to someone like Bernie Williams, who was the center fielder for the Yankees during their great championship run. Bernie, I'd say, was a star, but not a superstar. And I'd put Kurt in the same category as a star, but not a superstar. And as the documentary said, after the 1969 season on October 7th, 1969, just a few days ago from today, he was traded to the Philadelphia Phillies. And I along with Tim McCarver, and the main player coming back was Richie Allen. And I just want to put in context what getting traded from the Cardinals to being traded to the Philadelphia Phillies was like back then. The Cardinals were the best organization in MLB at the time, and the Phillies were definitely the worst. And the Phillies were regarded for black players as a prison sentence, as a horrible place to go. Kurt, in his autobiography, described Philadelphia as baseball's northernmost southern city. And I thought that was pretty apt. And Kurt knew that because one of his good friends from the Cardinals, Bill White, had been traded to the Phillies and had told Kurt how horrible it was. And the Philadelphia fans gave Richie Allen, one of their star players who was traded for Kurt, a horrible time there. So it was the principle of being the longest tenured member of the Cardinals being treated like a piece of property, but also it was this idea that, not the general manager didn't even call Kurt that morning on October 7th. There was kind of a person mid-level in the organization who had called him. I think hindsight's 20/20, but I think if the Cardinals had said to Kurt at the end of the season, "Hey, we're going to trade you. Where would you like to go? And what are your preferred destinations?" And Kurt's from the West Coast. And if Kurt had said the West Coast, whole thing would have, and they had traded him to the Dodgers or the Giants or whatever, I think this whole thing would have been avoided. But Kurt was blindsided by this. The GM did not call him. Just the backdrop for those who have only lived through the era of free agency. The Major League Baseball standard contract, which every player was forced to sign, said, we own you for this year, and we own you for next year too, right? And so at the end of every season, almost every player would sign a new contract. And before and if the player was traded, that option year, that sort of option, which is called the reserve clause, kicked in for the new team. So the new team owned the player forever and ever. And before the 1969 season, I think what really got Kurt traded was not dropping the fly ball and after the '68 World Series, but before the 69 season, Kurt had held out for more money. He wanted $100,000, which was superstar money back in 1969. And he stayed away from spring training, which is a player's only leverage in those days. Most of them, almost all of them, did not have agents. They negotiated directly with the club. And so Kurt stayed away from spring training and held out and eventually settled with the Cardinals for $90,000. But it left a lot of bad blood between Kurt and between the owner of the Cardinals, who he had enjoyed a good relationship with, Gussie Busch. And then Kurt had a down year in 1969. He batted .285, which was a down year for him. Be a great year in this day and age, but a down year for him. And he was traded, but he refused to go. And Marvin Miller tells part of the story, but on the Burns documentary, but it really doesn't tell what I found fascinating, what made me want to write the book. When Kurt goes to Miller, first he goes to a St. Louis attorney who was handling some of his business affairs and had handled his divorce, Alan Zerman, and Zerman advises him to go see Marvin Miller. And when he goes to see Marvin Miller, Marvin says, this lawsuit is 1,000,000 to 1 shot. And even if this 1,000,000 to 1 shot comes home, you're never going to see a dime, because all those contracts were legal at the time. And the only way people who will benefit will be prospectively. And Kurt said, will this benefit future players if I win? And Miller said, yes, it will. And Kurt said, that's good enough for me. And it was that kind of altruism was kind of the puzzle that I had in writing this book. What makes somebody who's just been advised by Miller to give up his entire career? And he had a good 2 or 3 years left with the Phillies. He probably left $250,000 at least on the table with Philadelphia over the course of those 3 years. And I say at least because Philadelphia offered him over $100,000 to come to Philly, and Kurt said no. And I just wanted to know what made Kurt want to do this. And the short answer, I think, is the civil rights movement and his. Kurt's from Oakland, California. He played for a multiracial American Legion team of Asians, African Americans, and white players. And when he goes to spring training with the Cincinnati Reds, his first team in 1956 in Florida, and tries to get in a white cab, and they shoo him into a black cab, and he shows up at the White Hotel, and they send him over to the boarding house with the other black players. That starts this culture shock of Jim Crow that he experiences for the first time, that continues during the 1956 season in the minor leagues. In High Point in Thomasville is a city in North Carolina and in the Carolina League. And even though Kurt was the Carolina Player of the Year, he wanted to go home. He wanted to quit. Things were so bad in terms of not being able to eat with his teammates, not being able to sleep in the same place as his teammates, not to be able to do a lot of basic things that one wanted to do, and just a lot of racism as one of the few black players in the Carolina League. And the next year he played in Savannah in the Sally League, and it was even worse than the Carolina League. And so, and then, that really kind of, and I don't want to say radicalized Kurt, but really sensitized him to injustice. And he gets traded to the Cardinals after his 1947 season in the Sally League because the Reds have too many black players. They have Vada Pinson and Frank Robinson, both of whom Kurt went to high school with for a while at McClymonds High in Oakland. And they weren't going to have an all-black outfield in Cincinnati, so they trade him to the Cardinals for nothing, basically. And in St. Louis, Kurt, again, was really sensitized to injustice. Even though he wasn't an everyday player at the time, he and Bill White and others protested the idea that the Cardinals were having spring training in St. Petersburg, and their team hotel would not allow black players. And Kurt and Bill White and Bob Gibson were staying at a boarding house, right? Separated from the rest of the players. And the Cardinals responded by buying that team hotel. Before the 1962 season, Kurt's idol, Jackie Robinson, invites him to come to Mississippi to speak at an NAACP rally. They're followed by the Mississippi Secret Police. Their host is Medgar Evers, who, a few months later is shot in the back and murdered by a Klansman. And then after he wins the World Series with the Cardinals in 1964, he had been separated with his wife, but they remarried, or I think he got divorced, and then he remarried his first wife, and they tried to settle in Walnut Creek, California, in the Bay Area, and they rent a house in an upscale white neighborhood, and they're threatened with a shotgun, and the owner of the house says, if you move into this house, I'm going to shoot you down, and Kurt gets a court order and armed police protection and moves into the house with the television cameras rolling. And so, it's not surprising if you knew Kurt's history in the minor leagues with the spring training hotel in Mississippi with Jackie Robinson, and in 1964 in Alamo, California, why Kurt sued Major League Baseball. The first people he really had to convince in 1969 were the other players. And the MLBPA, and let me just back up, right? Marvin Miller's the head of the Major League Baseball Players Union. He is not a lawyer. He's a former economist with the Steelworkers Union. But this is really ill-timed for Miller. He had just taken over in 1967. Kurt, in 1969, comes to him and says, I want to sue Major League Baseball over the reserve clause. Miller's a strategist. He doesn't want this now. He has only negotiated one collective bargaining agreement, the 1968 Basic Agreement. And in that Basic Agreement, the big thing that Miller got the players was an increase in the pension fund. So this was really a nascent union. The players were not united, as Kurt said in the video. There was not a lot of solidarity. There was a lot of skepticism when Kurt goes to Puerto Rico in the winter of 1969 to try to persuade the player representatives that the Players Association should fund his lawsuit. There was a stellar group of ball players, from veterans to rookies, in that room. One of the veterans was Roberto Clemente. One of the younger players was Reggie Jackson, and one of the most important questions came from Tom Haller, a catcher for the Giants, and he said, "Is this a Black Power thing?" And Kurt said, "No, this is a players' rights thing." And that won over all the players' representatives. Kurt's sincerity won over the players' representatives, and they voted unanimously to fund Kurt's lawsuit in exchange for being able to pick Kurt's counsel. And that's an important point that I'm going to come back to in a few minutes. So the Players Association agrees to fund the lawsuit, even though it's not good timing for Miller, even though he's about to negotiate the 1970 Basic Agreement, and yet they go forward. And what they go forward with is this letter. And I know you probably can't read it, but I'm going to read it for you. It's dated December 24th, 1969. It's written to Bowie Kuhn, the Commissioner of Baseball. You saw him at the end of that clip. And Kurt writes, after 12 years in the major leagues, I do not feel that I'm a piece of property to be bought and sold, irrespective of my wishes. I believe that any system which produces that result violates my basic rights as a citizen and is inconsistent with the laws of the United States and of the several states. It is my desire to play baseball in 1970, and I am capable of playing. I have received a contract offer from the Philadelphia club, but I believe I have the right to consider offers from other clubs before making any decisions. I therefore request that you make known to all the major league clubs my feelings in this matter and advise them of my availability for the 1970 season. Sincerely, Kurt Flood. And that letter is CC'd to Marvin Miller and to John Quinn, the GM of the Phillies. That puts Bowie Kuhn on notice. Bowie Kuhn replies and said, go jump in a lake, basically. You're bound by your contract. And that says that Philadelphia owns you for this year and next year too, and Kurt can't negotiate with any other team. Kurt's legal team responds by filing a lawsuit in the Southern District of New York and Lower Manhattan, and they have really 3 claims, but the major claim is about the Sherman Antitrust Act, and because this is a CLE, I want to get into some law, and Just to remind people, there are really two types of cases under the Sherman Act. There's a Section 1 case that prohibits any contract, combination, or conspiracy and restraint of trade that affects commerce among the several states. There's also a kind of Section 2 claim, which is when you're so big, basically, that you have cornered the market, essentially. And Kurt's claim was really about Section 1 of the Sherman Act. It was really saying that what the reserve clause was a conspiracy among the major league teams to refuse to deal. In the parlance of antitrust law, it was a group boycott. Right, the owners had gotten together and all said, none of us are going to bid on Kurt's services. Only Philadelphia is allowed. Now, under normal antitrust law, that's a per se violation of the antitrust laws. It's kind of a slam dunk. The reserve clause is a slam dunk antitrust violation on which Major League Baseball would have been liable for treble damages. Now, most sports cases since 1984 have been judged under rule of reason, which is the restraint of trade has to be found to be unreasonable. That's a more flexible standard, but I think even under a rule of reason analysis, Major League Baseball on the merits would have lost because the reserve clause was seen as a perpetual option, a lifetime ownership of Kurt's services, and that wasn't the least restrictive means of achieving the competitive balance that Major League Baseball was claiming that it needed from the reserve system. So on the merits, Kurt's case is a slam dunk. But as Marvin Miller pointed out, this really was a 1,000,000-to-1 shot, and the problem was really jurisdictional. If you look at Section 1 of the Sherman Act, it says that contract, combination, or conspiracy in restraint of trade must affect commerce among the several states. That means it has to be something that is interstate commerce, right? So the question is really a jurisdictional one. Can Kurt sue Major League Baseball in federal court under the Sherman Act? And there are two prior cases from the Supreme Court on point that say no, and they're a little bit misunderstood, right? They're a little bit misunderstood. The first case, called Federal Baseball, was written by Oliver Wendell Holmes Jr., and I apologize for the somewhat disrespectful caption, but I have law students and I need to interest them in these opinions, and I just think that Oliver Wendell Holmes had one of the great mustaches of all time, and this is proof positive. But this case involved the Baltimore team from the Federal League, which was a rival league, or quote unquote third major league in the second decade of the 20th century. They had merged. The Federal League teams had agreed to a merger with the major leagues. The owner of the Federal League team, the Chicago Whales, actually owned the stadium that became Wrigley Field. But they left the Baltimore team, the Baltimore Terrapins, out of the merger. The Baltimore Terrapins sued in federal court under the Sherman Act and won. They sued for $80,000 in damages, which were tripled to $240,000. That was reversed by the D.C. Circuit because they said that Major League Baseball was still sport and not trade. They did not even get to the interstate commerce point. They said it was sport and not trade, right? So if I go back to my previous slide, contract, combination, or conspiracy in restraint of trade, right? Well, there's no trade there, according to the D.C. Circuit. Now, Oliver Wendell Holmes Jr.'s unanimous opinion was different. It was more interested in the question on whether the Federal League was suing properly suing under the Sherman Act, on whether there was whether the commerce was A, interstate, and B, whether it was commerce at all, right? So those are two different questions. In 1922, what does Holmes say? One of the misunderstandings of federal baseball is that it exempted Major League Baseball from the Sherman Act. It really didn't. It didn't. It does not say that. All it says is that as of 1922, Major League Baseball, as constituted, was not they were consisted of a series of exhibitions that were not interstate. He said the business is giving exhibitions of baseball which are purely state affairs, and the travel to those different cities for those games, the transport was mere incident and not the essential thing, right? So he said, first, it's not interstate. Holmes's opinions were very short, and this one was super cryptic. But he said also it's not trade or commerce, right? He says, although, let me get to I'm having trouble reading my slide there for a second. Sorry. Although they make money, it would not be called trade or commerce it should be in the commonly accepted use of the words. As it is put by defendants, personal effort not related to production is not a subject of commerce. Basically, the labor is not commerce. And his examples, and this is great for this crowd, he analogized baseball players traveling to different cities as a firm of lawyers traveling to argue a case, and this is great for Jamestown, New York, the Chautauqua Bureau sending out lecturers, to different cities. He says that's not interstate commerce either. So I just want to be clear that Holmes did not say Major League Baseball was exempt for all time. All he's saying was that Major League Baseball, as of 1922, was not interstate commerce. And that's because of the Supreme Court's own decisions. There's a famous case about a federal child labor law in Hammer versus Dagenhart, which said manufacturing was not commerce, right? The definition of interstate commerce was really limited at that time. It was limited to the idea of trade. And so the notion of interstate commerce is super narrow. And if you don't believe me, you can read Kevin McDonald in the Journal of Supreme Court History. Kevin McDonald is an expert antitrust lawyer, was at Jones Day. He may be emeritus now at Jones Day, but he wrote this article proving this. And the real proof was in a case Holmes wrote in 1923 involving vaudeville. And vaudeville tried, they tried to get this kind of same quote unquote exemption about whether vaudeville was subject to interstate commerce. And Holmes said he kind of rejected this analogy between baseball and vaudeville. And his only point in that vaudeville case, it's called Hart, a year after federal baseball, was that Major League Baseball, as of 1922, just didn't satisfy the definition of interstate commerce, that over time, based on factual circumstances, baseball could fit into that definition if the business evolved. So this left this very open-ended about whether baseball had an exemption. In 1949 was the next really big challenge. And this is in your packet for those of you who want to follow along. The case was Gardella versus Chandler. Danny Gardella was kind of a fringe outfielder who had jumped to the Mexican League for more money. And for jumping to the Mexican League, he was blacklisted by the commissioner. I think it was Happy Chandler at the time. And he sued Major League Baseball under the Sherman Act. And the trial court dismissed the claim on jurisdictional grounds, but two rock stars of the Second Circuit Court of Appeals, Learned Hand and Jerome Frank, were on the panel, and they reversed and remanded to see if baseball satisfied the more expanded definition of interstate commerce as post-1937. Because as you know, the Supreme Court dramatically expanded its concept of interstate commerce during the New Deal constitutional crisis and upheld a bunch of Roosevelt's New Deal programs and overruled Hammer versus Dagenhart's limited definition of interstate commerce. And I'm pretty sure on remand, Danny Gardella would have won his case. But instead he settled. Major League Baseball knew that it was going to lose at trial and lose this quote-unquote exemption. It settled with Gardella for $60,000. That was a lot of money. And Judge Learned Hand didn't really opine on the reserve clause, but Jerome Frank, in a concurring opinion, or in his opinion, equated the reserve clause with slavery. And that's how we get this idea of a well-paid slave and equating this with slavery, and suggested it might even violate the 13th Amendment. Harry Blackmun, when we get to Flood versus Kuhn, ignores this case altogether and ignores two legal giants in Learned Hand and Jerome Frank in their opinion on this issue. The next big event occurs 2 years later when a congressman, Emanuel Seller from New York, holds hearings in the House Subcommittee on Monopoly Power to study whether Major League Baseball should be subject to the antitrust laws. A bunch of people testified. A big report was written, and as of that moment, Congress hadn't done anything, hadn't passed legislation exempting Major League Baseball or saying that baseball should be subject to the Sherman Act. That gets us to the next big case involving, and where the exemption starts is right here, right? The exemption starts here in a case involving a minor league pitcher who's stuck in the New York Yankees farm system, and his name is George Earl Toulson. And Toulson sues Major League Baseball, and there's a couple other companion cases involved with Toulson's case. The court grants certiorari in that case, right? And the court is at a weird kind of inflection point in 1953. Earl Warren's brand new Chief Justice to the Supreme Court of the United States. He was nominated to the court as a recess appointee, which means he had not been confirmed by the United States Senate. He was so new to the court that Hugo Black was serving as the acting Chief Justice because, Earl Warren had not had any prior judicial experience, had never argued before the Supreme Court of the United States. He was still really getting his feet wet. And the court hears oral argument in the case, and they decide to decide the case in a per curiam opinion. And they completely misread federal baseball, right? They say it's a one-paragraph decision. It should be in your packet. And it says, without re-exam, it begins. Their per curiam begins, and it was initially drafted by Hugo Black, and it says, without re-examination of the underlying issues. Well, let's just stop right there. That's exactly what Holmes wanted people to do. Holmes wanted people to re-examine the underlying issues based on the facts of Major League Baseball, right? And based on the current definition of interstate commerce, which had been dramatically expanded post 1937. And given that you have radio and the minor leagues and the beginnings of television, right? There's a much better argument that Major League Baseball is interstate commerce, but Toulson misreads federal baseball by not re-examining the underlying issue and by relying on stare decisis, and then it adds a line at the insistence of Earl Warren that really makes a mockery of federal baseball, where it says, we haven't re-examined federal baseball, but we're going to say that according to federal baseball, here's what Congress intended. So far as that decision, federal baseball, determines that Congress had no intention of including the business of baseball within the scope of the federal antitrust laws. This sentence, in effect, creates the exemption because it ascribes an intent to Congress in passing the Sherman Act in the 1890s of intending to exclude baseball. First of all, federal baseball did not say that. Second of all, the Sherman Act's legislative history has no evidence of that. So they are ascribing to an intent to the Sherman Act that does not exist in I think, was a very poor attempt to get Congress to act. But that addition of congressional intent created this idea of an express exemption for baseball. So far as that decision, federal baseball determines that Congress had no intention of including the business of baseball within the scope of the federal antitrust laws. That's the beginning of the exemption, right there in 1953. Now, if they had followed the law on the definition of interstate commerce, if they had read federal baseball properly, the court should have held that Major League Baseball was subject to the Sherman Act like everything else, like everything else, but they didn't. And that's where the court really fouled up and made a wrong turn and sort of stepped in it. And then there was one justice who I would regard, as I've told Greg before, as one of the most underrated justices ever to sit on the Supreme Court of the United States. Justice Harold Burton issued a dissent in the case. And he says, what are you guys doing? He says, look at the radio, look at television, look at farm systems. Those things make baseball seem way more like interstate commerce in 1953 than in 1922. I'm doing exactly what Oliver Wendell Holmes told us to do. The House subcommittee said baseball was interstate commerce, the Seller Committee, and all federal baseball said was baseball was not interstate commerce in 1922, not that it was exempt for all time. This is the proper reading of federal baseball, and only Harold Burton gets it right. And he cites as proof the vaudeville case, that Hart case, that it was only based on that definition at the time, and says, look, this is within Congress's power under the Interstate Commerce to investigate MLB. Of course this is interstate commerce. Well, they should have listened to Harold Burton, because the court gets itself in a box in a bunch of future cases, because lo and behold, after they exempt baseball, all these sports come calling for similar exemptions. Boxing, which is, besides baseball in the first half of the 20th century, the most watched professional sport, says we should be exempt too. And the court says, no, boxing is not exempt from antitrust law. It says federal baseball and Toulson don't apply. Well, finally, Felix Frankfurter kind of wakes up. And Frankfurter's not a sports fan, but he says, I don't see a lick of difference between baseball and boxing. So why are we exempting baseball but not boxing? Well, he's totally right. He's just should have woken up in 1953 and joined Harold Burton's dissent, but he didn't. And then it gets even messier in a case called Radovich, involving a lineman named Bill Radovich, whose picture you see here in 1957. The Supreme Court says, hey, football's not exempt either. And it calls, in a decision, I think, by Justice Clark, I could be wrong about that. I'm talking off the top of my head. It says the baseball exemption is unrealistic, inconsistent, and illogical, but it does not apply to any other sport. Well, some very smart lawyers, when the Braves moved from Milwaukee to Atlanta, and they tried to stop it, they said, okay, we're going to take the Supreme Court of the United States at its word, and if baseball's not interstate commerce, then it has to be intrastate commerce. We're going to sue under the state antitrust laws. And the Wisconsin Supreme Court said, hey, those state antitrust laws are preempted by this baseball exemption under the Sherman Act. Some of those Wisconsin Supreme Court justices lost their seat on the court for so ruling, because the Braves left for Milwaukee. Now, right before Kurt's case, there were two important legal developments. There was a case involving the umpires. Two umpires were fired for incompetence, but really for trying to unionize. And they sued the American League under the antitrust laws. And Judge Henry Friendly, another just an absolute judicial superstar, along with Jerome Frank and Learned Hand, wrote in a famous opinion. He called federal baseball not one of Justice Holmes's happiest days, and he would not fall out of his chair if the Supreme Court overruled it, but it was not up to the Second Circuit. Even Friendly, though, really misread federal baseball as creating an exemption when it didn't. He should have been taking aim at Toulson. And then in 1971, while Kurt's case is pending, Spencer Haywood applies to William O. Douglas as the circuit justice for the Ninth Circuit. And Douglas says, hey, basketball's not exempt either, and the NBA draft violates the antitrust laws and the rules on draft eligibility. So you've got a trend and a moment where there's a chance the court might overrule Toulson, but sort of unlikely. I think it's a long shot. And the weird thing about Kurt's case when it progresses through the courts is any federal judge who'd kind of studied federal jurisdiction would know that the court didn't have jurisdiction to hear the case, and that if the court doesn't have federal jurisdiction, then you dismiss the case. No trial, no discovery, dismissal. Well, there was no discovery in Kurt's case, but it did go to trial because their trial judge, Irving Ben Cooper, was a total publicity hound, and he brought in all these celebrities on both sides. And as the Burns documentary showed, Bill Veeck, Jackie Robinson, Hank Greenberg, and Jim Brosnan, all former players and executives at the time, testified in favor of Kurt, but a parade of witnesses testified against him and against this idea that baseball was interstate commerce, or that on the merits whether the reserve clause violated the antitrust laws, all things that Irving Ben Cooper shouldn't have been discussing because he didn't have jurisdiction. And then he dismisses the case after the trial, citing federal baseball. The Second Circuit affirms Kurt, during this process, has sat out the 1970 season. During this trial, and this is really important, Marvin Miller is negotiating the new Major League Baseball collective bargaining agreement, the 1970 Basic Agreement, and that's really key. And I'm going to get back to that in a minute. I promise. But just keep that in mind. So Kurt does something in 1971 that the Burns documentary kind of glosses over, but I think was one of several big mistakes in his case. The first was something Kurt did allude to in the documentary. No current players showed up in New York during Kurt's trial to show support for him. None. Even though you had the Mets and the Yankees, players coming into town constantly, you could have had players showing up in that courtroom showing their solidarity, and they didn't. I don't know if it would have made a difference, but it was certainly from a public relations standpoint where much of the media was against Kurt's lawsuit. I think this would have gone a long way to show that Kurt wasn't out there on his own. Marvin Miller admitted this was a huge strategic mistake. Another huge strategic mistake was Kurt made an aborted comeback in 1971 with the Washington Senators, and he was in dire financial straits. His outside photography business was going bankrupt. He owed back child support and alimony. He needed to really declare bankruptcy, and he couldn't because his biggest asset was this lawsuit. And he had promised the players in Puerto Rico that he would see it through to the end. And so he doesn't declare bankruptcy, and instead he makes this comeback with the Senators, and Kurt's lawyers get an agreement with MLB that this won't moot the lawsuit, but it made the case seem moot. And from an optics standpoint, when Kurt comes back for only a couple of weeks and then leaves for Mallorca, Spain, it made his case seem somewhat moot or irrelevant. And I think had Kurt still been sitting out in 1971 and 1972, I think there would have been more gravity to the whole thing. He would have looked more like Colin Kaepernick, just to make a modern example, as somebody who was blackballed by the sport. So Kurt has left for Spain. The Supreme Court shocks everyone by granting certiorari, right? The reason why it's shocking, if there's no jurisdiction to hear the case under the Sherman Act, the path of least resistance for the Supreme Court, if it wants to just let the lower court decision stand, is simply to deny certiorari. But the court doesn't do that. It grants cert. So you think the court might rule in Kurt's favor. And Kurt's team thinks he has an ace in the hole in his advocate. Kurt's counsel, chosen by Marvin Miller, this was Marvin Miller's second error, was his choice of counsel, was Arthur Goldberg, the former Supreme Court justice. He had gotten to know Miller when Goldberg was the general counsel of the Steelworkers Union and a first-rate labor law advocate. Let me say that right then and there. Goldberg had participated in the argument in the steel seizure case, where Justice Jackson wrote his famous opinion. He was a first-rate advocate at one time. He then becomes John F. Kennedy Secretary of Labor and succeeds in 1962, succeeds Felix Frankfurter on the Supreme Court, but leaves after just 3 years because Lyndon Johnson, who's now president, persuades Goldberg to become the ambassador of the United Nations because he promises to Goldberg if he becomes ambassador to the United Nations, that he'll be able to end the Vietnam War. That Johnson in 65 wants to end the war, and that Goldberg will get all the credit, and then Goldberg could launch his own political career. And Goldberg has a huge ego. He believes Johnson. He becomes the ambassador to the UN, and as we know, does not end the Vietnam War. He serves in the Johnson administration, then becomes a partner at Paul Weiss in New York City, and before he agrees to become Kurt's counsel, Miller's read in the paper that Goldberg's thinking about running for governor of New York. And they go way back, and Miller says to Goldberg, he says, "Hey, you can't run for governor of New York and be Kurt's counsel." And Goldberg promises that he's not running for governor of New York, and he breaks that promise. Runs anyway, loses. He's really distracted during much of Kurt's trial and appeal, certainly during the trial. And likewise, he doesn't really prepare for his Supreme Court argument, his first time appearing back at the Supreme Court since he was one of the justices, and he really freezes. He almost like has a mental moment where he gets stage fright and he starts reciting the facts, almost like a feedback loop. It was a disastrous oral argument. Before I play a little bit of that oral argument, Greg, I know I'm almost an hour in, but I want to play some argument and talk for a little bit longer. But I want to just tell you what the arguments are. Their first argument for Flood's legal team is that the Sherman Act applies because in 1969, baseball's interstate commerce because of radio, TV, the minor leagues, etc. Their second argument is that the Reserve Clause violates the 13th Amendment. Now, I know the reporter in that clip in the Burns documentary mentioned that. It's standing outside the Supreme Court, but they dropped that claim after their Second Circuit appeal. So that claim is not before the Justices of the United States Supreme Court. And their third claim, which is really their hard argument, and the one that the justices are really struggling with, is, hey, you can't have your cake and eat it too. Either baseball's interstate commerce or it's intrastate commerce. And if it's intrastate commerce, then the state antitrust laws apply. And they also included state antitrust claims. That's a hard argument for the court to get around, right? It's either interstate or intrastate. Pick one. Either way, we win. Major League Baseball's arguments are super fascinating. Their main argument is this is a labor issue and not an antitrust issue, and therefore it's exempt under what today we call the non-statutory labor exemption. And that's a very complicated way of saying that if you're in a labor union and you agree to a collective bargaining agreement, you can't then turn around and sue under the antitrust laws. You can't have it both ways. And that's a hard argument for the court, and that's kind of a new-ish argument. There's a Yale Law Journal article published in 1971 that's co-authored by Ralph Winter, who's a Yale Law professor and future Second Circuit justice, who said that all sports unions should not be allowed to sue under the antitrust laws under this non-statutory labor exemption idea. Now, they would respond to the state law antitrust law argument by saying that any state antitrust claims are preempted by the Sherman Act or violate the Dormant Commerce Clause. I can get to that in a little bit. Their third argument is stare decisis, which means let the decision stand. And they say, look, Major League Baseball has a lot of reliance interests on its exemption, the development of the minor leagues, franchise relocation. They've invested a lot of money in the minor leagues and in their stadia, and they can't lose the exemption, and even in developing the players themselves. And then I think their last argument is that Congress has not acted since Toulson to remove the exemption. And I'll talk about that one too. That one is the weakest of all the arguments, and oddly, the one that the Supreme Court chooses. Let me go to the oral argument real quick. Greg, is that okay if I do that?
That's fine.
Can I keep rolling?
Yep, keep going.
just need to change my screen here. I just want to play first a colloquy between Justice Brennan and Arthur Goldberg, and they're really good friends, right? Brennan and Goldberg were friends, and Goldberg's rambling on about the facts, and Brennan asks him a really important question about this idea of whether a union should be able to sue under the antitrust laws. Let me just play this short clip.
May I ask you, suppose it had been collectively agreed to, would your position be any different?
No. And I shall discuss that when I come to the labor exemption.
I hope you're going to get to that.
I will move that. Because of the shortness of time. We have these people.
Now listen, I know I have a bunch of lawyers in this room. When a Supreme Court justice asks you a question at oral argument and you say, and I'll put the language up there, no, and I shall get that when I come to the labor exemption, your friend has teed up the other side's best argument and wants a response to it, and you don't get that. You say, I hope, and then Brennan says, I hope you're going to get to that. And Goldberg says, I will move fast, and the courtroom laughs. That shows you in how much trouble Goldberg is in before the Supreme Court of the United States. Just really a world of trouble. And the advocates on the other side are just excellent for Major League Baseball. Lou Hoynes was 36 years old. He was the counsel for the National League. He's arguing his first Supreme Court case, and he does an amazing job of pressing this labor exemption issue. And I want to play a clip of that, if you'll bear with me in getting to this question, okay? Let me just try to do that real quick here. Thurgood Marshall is giving Lou Hoynes business. And really, Thurgood Marshall's point in questioning is he really thinks that the union is not acting in Kurt's best interest. And I'm not sure Marshall's right, but Thurgood Marshall's former law clerk is Ralph Winter, the law professor who's written this article on the labor exemption in the Yale Law Journal. And so he's got a lot of questions about this. And let me just play this clip for you, because I think it's a really good example of Hoynes' advocacy vis-a-vis Thurgood Marshall.
Wouldn't you say under reserve clause there was no room for bargaining?
No, I certainly would not say that. I would say that the reserve clause itself, the very core of the reserve clause, is a subject admitted by both sides, a mandatory subject for bargaining, and something about which bargaining was going on when interrupted by the pendency, the filing of this lawsuit. And it is back to that forum, Your Honor, that we believe this matter should be remitted.
You mean back to the union?
Back to the collective bargaining, to the bargaining table, Your Honor, yes.
Well,
look, that's a really important point, and that really encapsulates MLB's case. MLB is saying, look, this is a labor issue, not an antitrust issue. We can be reasonable. They even put their money where their mouth was during the negotiations of the 1970 Basic Agreement. They gave the players grievance arbitration, and that is the ability to file grievances before independent arbitrators, not the commissioner, independent arbitrators, and that proves to be incredibly important. So I just want to keep in mind that Major League Baseball's point here is that this is a labor issue, not an antitrust issue. Now, that wouldn't really control franchise relocation or even the minor leagues, because the minor league players aren't unionized at the time. So Hoynes recognized he was walking a tightrope, but that was really the thrust of their argument, which was really hard for the court to deal with. Here's what happened at conference. Here are the votes. So I just want to go down the list because I think it helps to visualize it. Chief Justice Berger votes for flood. William O. Douglas votes for flood. Brennan votes for flood. Potter Stewart votes for MLB. Byron White votes for MLB. Thurgood Marshall votes for MLB after really hammering Lou Hoynes. Harry Blackman votes for MLB. Lewis Powell votes for flood, but stay tuned on that vote. And William Rehnquist votes for MLB. This is a 5-4 case initially in favor of MLB. A good argument by Flood's advocate before the Supreme Court of the United States might have persuaded one of the justices to change votes. Indeed, a lot of stuff happened after this conference, after the oral argument. The first thing that happened was Lewis Powell recused himself after oral argument because he owned Anheuser-Busch stock. Anheuser-Busch owns the St. Louis Cardinals, and Lewis Powell had promised at his confirmation hearings, after some of Richard Nixon's other judicial nominees had gotten in trouble for owning stock in cases that they sat on as appellate judges, said, I'll recuse myself in any case in which I own stock. He recuses himself, so it's now 5-3 for MLB. But a crazy thing happens. When the opinion gets circulated, Thurgood Marshall switches his vote to flood. It's now 5-4. Okay? It's deadlocked. And the assignment goes like this. I'm going back to this slide because the senior justice in the majority, as you see, is the fourth most senior justice. It's Potter Stewart. And he assigns the case to one of the newer justices on the court, to Harry Blackman, right? And so Blackman's writing the decision, and when Blackman circulates, it's now 4-4 when he circulates. He needs a fifth vote, and he gets it from his childhood friend, the Chief Justice, Warren Burger. They were childhood friends in Minneapolis, St. Paul. Blackman was the best man in Burger's wedding. They were called the Minnesota Twins, right? But Blackman's opinion was an embarrassment. It starts with this ode to baseball, citing Casey at the bat, and he really, in writing the opinion, obsesses over this list of baseball greats that he compiles from books such as The Glory of Their Times, and the law clerks kind of make fun of him, suggesting different names of great players, and the opinion, that first part of the opinion, is such an embarrassment that Byron White and I think William Rehnquist refused to join part one. It's almost unheard of for a justice's opinion for someone to not join the facts. And here's what Blackman says in the decision. Blackman concedes that Major League Baseball is interstate commerce. And the question has to be, well, why, if you concede that Major League Baseball is interstate commerce, do the antitrust laws not apply? Well, first he says because of stare decisis, right? But the second reason might be because of problems with retroactivity. Well, that's easily solved. You could make the decision prospective, right? But the third reason's really crazy. And that's, he says, because of Congress's, and this is a direct quote, positive inaction, this is up to Congress to fix. Anyone who knows anything about statutory interpretation is that Congress's default mode is not to do anything, and that you can't interpret a federal law based on Congress's inaction, right? Because that's its default position. And, if you look at Congress's inaction, there were a lot of bills in Congress between 1950 and 1972 to exempt all four major professional sports, and those bills didn't pass either. So that argument really is a red herring. And that's what Blackman bases his decision on, Congress's positive inaction. It's a really bad argument. He spent very little time developing the reasoning for that. And then lastly, he rejects Flood's state antitrust law claims if Major League Baseball was interstate commerce. He says they would violate the Dormant Commerce Clause. And that's the idea of a state law interfering with interstate commerce in the absence of a congressional law. But that doesn't really make sense either, because if baseball is interstate commerce, then the Sherman Act should apply, and there is a federal law on point. So it should be preempted. It shouldn't be the Dormant Commerce Clause. And then on this idea of the labor exemption, Blackmun kind of punts, right? There was some language in the reserve, in the collective bargaining agreement that sort of accepted the reserve clause from that collective bargaining agreement. And therefore, the court really didn't know what to do with that argument and just kind of punts on it. Now, Thurgood Marshall, in his dissent, he goes from in the majority to dissenting, says this is a hard case, right? And he's correct to say the court doesn't often overrule itself on cases of federal statutory interpretation, but Toulson was dead wrong. He said our remedy could be prospective. He said stare decisis alone is not a good reason to keep federal baseball, and he would remand the case to the trial court to see if they're exempt from federal law only on the issue of whether the reserve clause had been collectively bargained, if it was part of the 1970 basic agreement. So he's really interested in this labor exemption issue, and he would remand on that. I just want to point out one thing. The Brethren, that book by Bob Woodward and Scott Armstrong, claims that Thurgood Marshall objected to Blackmun's list of great baseball greats because there were no black players on the list, and that Blackmun had left out Satchel Paige and a few others, and that Marshall made him include them. Well, that's hogwash, because at least the drafts in Blackmun's papers show that the black players were in there from the get-go. That's at least one strike against the Brethren. The other dissent, and the dissent that I really think is fantastic, is William O. Douglas. He says that federal baseball is a derelict in the stream of the law, and he drops a footnote in his opinion saying he regrets joining Toulson. I think he's the only justice on the court from Toulson. And he says he regrets joining Toulson, and that congressional inaction is a bad guy because Congress hasn't expressly exempted baseball or any other sport. And the only exemption that we have is for broadcasting, and that's the Sports Broadcasting Act. And he says, hey, this is the Supreme Court's mistake, and the mistake was really Toulson, not federal baseball, and we should fix it. Those are the opinions, and I just want to briefly kind of add a couple of postscripts. Well, how if Curt Flood lost 5-3 on a ridiculous opinion by Harry Blackmun, did Major League Baseball get free agency? Well, as I said, in 1970 during the trial, when MLB says we can be reasonable and they throw the players a bone by giving them grievance arbitration, well, that becomes for the players the kind of silver bullet. The first free agent, and most people forget this, was Catfish Hunter. Catfish Hunter became a free agent because the Oakland A's owner, Charlie Finley, had breached his contract by not setting up half of the contract as an annuity. And an independent arbitrator, Peter Seitz, ruled that Finley was in breach, and the remedy for that breach was to make Hunter a free agent. And Hunter signs a multi-million-dollar contract with the New York Yankees. I think it was $1.9 million. And that really opened up everybody's eyes to what Curt was fighting for and the possibilities of free agency in Major League Baseball and all professional sports because of what Hunter, a great pitcher, got on the open market. A year later, two other pitchers, Andy Messersmith and Dave McNally, also filed grievances. They've done something called playing out their option year. At the beginning of my talk, I said the reserve clause says if we own you for this year and next year too. Well, the Messersmith and McNally and other players that tried this before essentially played out that option year. They played a season under their own old contracts, right? So they said, okay, if you own us for this year and next year too, we're going to play next year without a contract, and then we should be free agents. And Peter Seitz, who was still the arbitrator, the owners hadn't fired them. They could have, and they should have, because he had ruled against them in the Hunter case. He ruled that the reserve clause was only a one-year option and not a perpetual one, not a lifetime option, and that essentially ended the reserve system, ended and led to free agency, because at that point, the players and the owners got together and negotiated a free agency system in the next collective bargaining agreement. So Kurt's lawsuit, although a loss at the Supreme Court, was really, I think, a win for the players because they won grievance arbitration that led to free agency in 1975. What happened to Kurt? Well, we know a little bit. Now, the Ken Burns documentary glosses over some of it, but in 1976, he returned to the United States from Spain, where he had been self-exiled, drunk and destitute. From 1976 to 1986, Kurt had a really hard time. He struggled to regain his sobriety in Oakland. He briefly announced games for the Oakland A's as a color commentator. That really didn't work out. But in 1986, he really got his life together. He married a former girlfriend, the actress Judy Pace, who's pictured second to the left here. A big moment for Kurt came during the 1994 baseball strike, when he appeared at a meeting in Atlanta of the players and received a standing ovation. And that was really the first time the union had publicly acknowledged what Kurt had done for them. And then, of course, he makes that star turn in Ken Burns' baseball documentary that you listened to. And the people who were in that documentary and Burns himself had an event at the White House, and Kurt got to meet President and Mrs. Clinton, and you see they're pictured here with Bill Clinton in the middle and Hillary Clinton to his right. I just point out, like, look how young they look. It's kind of remarkable how young the Clintons are in that photograph. But sadly, when Kurt has finally started to receive his due in '94, he died of throat cancer in 1997. And but Kurt's story kind of continues here, and where it continues is after the baseball strike, the union got what they thought was a concession from Major League Baseball. They got so what they called the Kurt Flood Act of 1998. It's really unfortunate. It's named that. It removed the exemption, baseball's exemption from the antitrust laws, as it relates to employment issues of major league players. And that's really a nothing burger, because the Supreme Court had ruled in 1996 in a case called Brown versus Pro Football Inc. that unions cannot be unionized and sue under the antitrust laws. So as long as the MLBPA exists, they can't sue under the antitrust laws. So that's a nothing burger. What the players got, nothing. And what the owners got is a laundry list of what the Kurt Flood Act didn't cover, which includes the minor leagues, the draft, franchise relocation, umpires, the Sports Broadcasting Act. Basically, it got an affirmation in Congress of the antitrust exemption. And the union got nothing and lost a ton. It was a huge strategic mistake by the Major League Baseball Players Association. And it really hurt minor league players who were non-unionized, so they didn't have a protection of the union. And they were now, according to this law, exempt from suing under the antitrust laws based on the Kurt Flood Act. Last thing, and then I'll turn it over to Greg. Will Flood v. Kuhn be overruled? Flood v. Kuhn is an embarrassing decision. The court almost never cites it in a positive light. In a recent antitrust case about the amateurism rules of the NCAA and NCAA versus Alston, the court unanimously, the great thing about antitrust cases is there's really a lack of political valence in these cases. As you saw from Kurt's case, liberal and conservative justices were all over the map. That's true also today. 9-0. They ruled that the NCAA's amateurism rules violated the Sherman Act. But in that majority opinion by Neil Gorsuch, who is an expert on antitrust law and used to teach it, basically put MLB on notice about how aberrational and unsupported Flood v. Kuhn is. there is bipartisan support in Congress to end baseball's antitrust exemption. Also, this is I know MLB's monopoly is strong, and their lobbying efforts in Congress is super strong, but MLB is on the run. They allowed minor leaguers just recently to unionize. The players voted to unionize, and then rather than sort of contest it in the NLRB, the Major League Baseball agreed to allow the minor leaguers to unionize because they want the benefit of that labor exemption. I think they're worried about the antitrust exemption from Toolson going away. This is a Supreme Court, as most of you know, that is not real concerned with following precedent. The only good argument in Flood versus Kuhn was stare decisis and following precedent. And this 9-0 decision in Alston should have sent shivers down the spine of Major League Baseball. There is a case pending in the lower courts about minor league teams. There was a contraction of minor league teams by Major League Baseball. One of those contracted teams, the Staten Island Yankees and a few others, sued Major League Baseball under the Sherman Act. That case is pending in the lower courts. And what I'll say about that is stay tuned, folks. I'll be really interested if the Supreme Court of the United States grants certiorari in that Staten Island Yankees case. I think there's a very good chance that Flood versus Kuhn could be overruled. I'm going to stop there. I've talked for a long time. I've exceeded my limit by a lot. Greg, I hope I haven't gone on for too long, but fire away.
Wow, that's incredible, and I'm delighted on so many fronts, personal as well as professional, to get a master's class in baseball. As I mentioned, I'll be put myself on the stake here a little bit. When I mentioned to you last night, 1973, I wrote my senior thesis on the Flood versus Kuhn case, and anticipating from an economic class what would happen to baseball should the reserve clause be ended. And I was so wrong, so that's why I'm not sharing it in this booklet. But so it's great for me to be corrected on so many fronts by you, Brad. And of particular interest, the follow-up luncheon speaker is the John Dandies. John is the president of Bison's Rich Products Sports Entertainment. They own the Buffalo Bisons, and he's actively interested in what's going on in Congress right now, as they are reviewing this whole antitrust exemption. And of course, the last sentence you had was talking about the Staten Island Yankees, which was a member of the New York Penn League, of which Jamestown team was a part for so many years. So you brought it really home, and I'll report whatever John talks about during lunch. In fact, why don't you, that's probably a segue to help me, is what is going on in Congress right now? Have you followed any of the congressional hearings insofar as the antitrust exemption?
No, I haven't. I have to be honest. I know there are even people on this call who know more about this than I do. I do know there's support on both sides of the aisle. A co-sponsored bill by Republicans and Democrats, and 20 years ago that would be so what. But I think anytime you get Republicans and Democrats agreeing on something, it's kind of remarkable today. And there's also bipartisan support, I think, in general, Greg, for that monopoly is bad, particularly when it comes to big tech. If you think about the bipartisan outrage about big tech and the need to hold big tech's feet to the fire in terms of the antitrust laws, that doesn't bode well for Major League Baseball either, right? I just think, I think there's a sense on both sides of the aisle that monopoly is bad. Now, let me just say that there is a major league team or a minor league team in so many of these senators and congressmen's districts, and that their lobbying shop, MLB's lobbying shop, is unparalleled, and that a lot of arms will be twisted. And I think it's going to be a heavy lift for Congress to do the work to remove baseball's exemption through legislation. So I'm not optimistic on that front. I'm actually more optimistic that the Supreme Court will bury Toulson and Flood v. Kuhn, since it was their mess. So I think that in this case, we've got a better chance. Again, I don't think it matters that this is a conservative court. I think justices like Neil Gorsuch and Brett Kavanaugh are outraged about abuses of monopoly power in this sort of way. In the past toward minor leaguers, and most recently toward minor league teams in contraction. And that baseball, I think this exemption has shown what happens when a monopolist has an exemption and how they abuse that power.
Could you envision what happens to organized baseball the minute either the Supreme Court or Congress passes legislation which eliminates the antitrust exemption? What would change?
It would force baseball to get its act together, to innovate, and to look more like the NBA, and to have a kind of, I'm not going to mince words, to have a commissioner who's kind of forward thinking about how to grow the game, to realize that it's not an us-them mentality, right? And to not make comments denigrating the World Series trophy or denigrating or saying that minor leaguers are making a minimum wage when they're not, and to realize, like Adam Silver does in the NBA, that he's involved in a partnership with the players and that he needs to figure out how to grow the game. It just may force MLB to be less of a dinosaur and to be more of an innovator and put it on the same playing field as other professional sports.
My boss is over my shoulder for just 1 second, Brad, because she's going to make a very important announcement.
I'm breaking in for your second attendance verification code. It is ZWE 536. That's Zebra Whiskey Echo 536. ZWE 536. Thank you.
And if you noticed, Brad, if you were watching me, I was marking that down so I make sure that I too get this important credit here, so that everybody knows that it's ZWE 536. You can mark that down on your day calendar as a special. And I don't know who actually makes up those numbers, but they're amazing.
It's like a license plate.
Yeah, exactly. You have, just for the audience, everybody needs to know that this guy was a sports writer. So it's not like he's some academic sitting down in Georgetown. He cut his teeth as a sports writer in Baltimore, as a Baltimore Orioles fan, and in fact, he covered the most famous game in Baltimore Orioles history for the a local newspaper. You want to briefly talk about that? In your you blew right by it in the biography.
I hear you. I wouldn't say Ripken. I was covering for the Baltimore Sun when Cal Ripken broke Lou Gehrig's record on 21-31. And Greg, I know you have the date on the tip of your tongue.
September 6, 1995.
I was there that day, and I was a young sports writer with the Baltimore Sun. I don't think that's the greatest day in Oriole history. I'd take the 83 World Series or the 70 World Series with Brooks Robinson either day. But that's the kind of fan aspect in me. But it was certainly a high water mark for the franchise and super memorable. But, I got there out of college in 94 and the baseball strike hit. And I sort of started educating myself about the history of antitrust and labor in professional baseball. And I was kind of embarrassed as a sports writer about how little I knew about Curt Flood, that here I was covering baseball for a major newspaper and didn't really understand what Curt had done. And I really, that first year as a reporter, saw Curt's story as a great one-man takes on the establishment story. And I just read Anthony Lewis's amazing book, Gideon's Trumpet, and really, which is about Clarence Earl Gideon, who didn't have counsel and was convicted of a of a burglary in a pool hall in Florida and was indigent. And Clarence Earl Gideon wins based on a handwritten petition to the United States Supreme Court. In a very famous decision establishing a right to counsel in all felony cases. I saw Kurt's story way back then as baseball's Gideon's trumpet. And even though Kurt lost at the Supreme Court, I really think he won. He really raised not just public awareness about just how unlevel that playing field is, to borrow the title of your program today, between the owners and the players. And just by going on Howard Cosell and saying a well-paid slave is nonetheless a slave, and Cosell, of course, was ESPN, Fox, CBS, and every other network rolled into one back then, right, in terms of power. To say that really opened people's eyes to the inequities in the game, and then to force the union to say that, hey, not the union, I'm sorry, the league to say, hey, this is a labor issue, not an antitrust issue. We can be reasonable. I just want to point out, in the next basic agreement, they get some really important things in 1973. The two concessions they get in 73, even after they've quote unquote lost in the Supreme Court, they get, first they get something that was at the time was called the Kurt Flood rule. And today we know it as the 10-and-5 rule. And that is with 10 years of major league service time and 5 years with the same team, that you can veto any trade. That rule still exists today. And lots of players have exercised it. The last member of the Orioles that exercised it was Adam Jones, their kind of team leader and star outfielder. And he, as the Orioles were in decline, they tried to trade Adam Jones, and he said, no, I'm exercising my 10-and-5 rule rights. And these rights have to be waived all the time, and that's all because of Kurt Flood. And the second major concession in that 73 basic agreement, after the MLB has argued this is a labor issue, is salary arbitration, which is after 3 years of major league service time, the players and the owners go to salary arbitration. And so years 4 through 6, they have salary arbitration that the owners are still regretting giving the players salary arbitration, right? And again, that's a major gain from Kurt Flood that's still baked into the current collective bargaining agreement, as is the 10-and-5 rule. And Kurt Flood deserves credit for both of those, which was why they named the 10-and-5 rule at the time the Kurt Flood rule.
Well, I just want to say, Brad, you deserve a lot of credit for bringing to our attention here, for all those publicly in person and those who are many watching online, this great story. Though it's 50 years later from the Supreme Court case, it is so relevant today, especially in the wild world of minor leagues, of which our world is a part here.
Yeah, well, I appreciate that. And one other thing I just wanted to mention, Greg, was you brought up the sort of, and even the announcer in the case in the Ken Burns documentary brought up that the best teams will get all the best players and the worst teams will get all the scrubs. And first of all, I don't think that's true today. But as I told you last night, Greg, when we were talking, Bowie Kuhn was really not a popular commissioner, and he was described by Charlie Finley as a stuffed shirt, and he called him a village idiot. Those are Charlie Finley's words, not mine. But Kuhn was so fixated on the end of the reserve clause as the end of the game that he didn't really see the train coming. And the train that was coming and that ran him over was the beginning of cable television. And once Ted Turner starts TBS and WGN starts in Chicago, the train has left the station, right, on cable television, and these and the inequities between big market and small market teams are really about these local television rights and these cable stations like Nesson, like the Yes Network, that just make the Yankees and the Red Sox and the Cubs and the Braves and the Dodgers, they have so much more cash at their disposal to spend on player development and to spend on ball players. And that's what I think really makes MLB different than the NFL, where the NFL's sharing all their money equally. But, Kuhn couldn't even get a more equitable distribution of that cable money because he just wasn't fixated. He didn't see its impact on how the disparity on local television revenue could create a have and have not system in MLB. And that's something, again, for a future commissioner to fix as we move away from cable television and as we move into streaming. And soon, cable television will be a dinosaur, much like network TV. And then MLB has an opportunity to kind of reinvent itself. And that's what I mean by without an exemption. Maybe MLB will start to innovate and really rethink its economic model in a world where streaming is everything.
Well, enjoy the playoffs via streaming, Brad Snyder, and thank you very much for all your time. Brad Snyder.
Thank you. I appreciate it, Greg.
And I might personally thank you so much for making the extraordinary effort. I know that pounding down some tea and whatever else you had to take on to get through this today was above and beyond, and we really appreciate it. Thank you.
It's my pleasure, Greg. Next time, I just want to come to the Jackson Center in person.
Okay.
So thanks so much.
We'll make that a reality. Thank you.
All right. Take care.
Bye-bye.
Thank you, Brad. Thank you, Greg.
Do you guys ever have any reason to talk about that?
Well, yes. So I think it would have been Justice Blackmun's, it might have been his 80th birthday, but it was one of his big birthdays. We were having a clerks reunion. And as you know, in Flood against Kuhn, which is the baseball antitrust case, there's this kind of passage at the beginning of it that's a list of famous baseball players, and it goes on and on. And apparently he started out with about 10 of them. Then various people around the building would suggest people, and then somebody said, well, but if you're going to include, if you're going to include Tinkers, you have to include Evers. Oh, if you're going to include Evers, you have to include Chance. And so that list kind of expanded and expanded. And there was a story in the Brethren that right after the opinion came down, somebody said to him, how could you not include Jimmy Fox? And he said, Jimmy Fox was on the list. And the person said, no, he's not. And the justice went back and looked at the list, and sure enough, Jimmy Fox is not on the list. And the line in the Brethren is something like, and Justice Blackmun said, I'll never forgive myself. So for his 80th birthday, I think it was his 80th, we decided we were going to get him one of Jimmy Fox's bats. And we looked into it, and we could not find one. But it turns out that Hillrich and Bradley, I think that's what the Louisville Slugger company's name is, they keep the measurements of every player on file for their bats. And so we went to them, and we had them replicate one of Jimmy Fox's bats, and we had it mounted on a plaque, and on the bottom it just said, I will never forgive myself, H-A-B. And we gave it to him, the clerks all gave it to him for his birthday, and I saw it actually posted in his chambers the day he died. After his funeral, we all went back to the chambers to hang out, and there was the bat, which I think was, several people asked for it, but I think it was given to the Library of Congress. And the other thing about baseball is he had been a friend of the Griffiths, who owned then the Minneapolis Millers, later the Twins, and so we would talk about baseball a lot at breakfast. And one day in the afternoon, I was in the upstairs chambers, and I got a phone call, you should come down. The justice has somebody he wants you to meet. And this group called the Emil Verbin Society was having its reunion in Washington. I guess it's a Cubs thing. And so there were these 3 guys in like bad-fitting sports coats in his office, and he introduced them to me, and 2 of them I don't remember the names because I'm not a Cubs fan at all, but the last one was Andy Pafko, who had been a Dodger as well. And so I had a nice conversation one afternoon with Andy Pafko. And the last baseball thing I'll tell you is when Justice Blackmun retired from the Supreme Court, I was asked to do one of the tributes for him in the Harvard Law Review. And one of the things I talked about in the tribute was this article that had been written called Your Law Baseball Quiz. I think I told you about this last night, where they compare different justices to different famous baseball players. And I said that, and so I tell the story of, Jackie Jensen is like Byron White because they were both better at football. And then I say, the guy who did this compared Felix Frankfurter to, among other things, Wayne Terwilliger. And in the article I just had a footnote, I said, who is Wayne Terwilliger? And then ultimately I said that if I had to pick somebody for Justice Blackmun to be like, I had thought originally about Bobby Brown, because Justice Blackmun wanted to be a doctor, just like Bobby Brown became a doctor. And that I thought of, a couple of other people like that, Charlie Gehringer, because he was a little tiny, little tiny second baseman, and, a great fielder, but not a big batter. And ultimately I came out with Dave Winfield, which people might not have guessed, because both of them came from St. Paul and made something of themselves. Both of them played the game long after many of their contemporaries had retired, and both of them owed their start to a convicted but later pardoned Watergate felon. To a later pardoned Watergate felon, because Blackmun got his seat on the Supreme Court from Nixon, and George Steinbrenner is the person who gave Dave Winfield his biggest contract. And so when so I read this, and I went and and the next time I visited the justice said, "Oh, I really liked your tribute a lot, but come with me." And he led me down the hall into the storeroom. He was then down at the Thurgood Marshall Center, and he pulled out a copy of the baseball encyclopedia, and he said, "This is Wayne Terwilliger," and took me to the page for Wayne Terwilliger.
Twig.
I'd never heard of him, and I'm a baseball fan, and I'd never heard of him.
Should baseball retain its antitrust exemption?
Well, I'm a big Bill James fan, and Bill James has a discussion of this where he says that if you got rid of the antitrust exemption, what you might start to see is a kind of proliferation of a third or fourth major league almost coming out of minor league teams. I'm not sure what function the antitrust exemption really performs today, given that there's now an agreement between the Players Association and the teams, right? And a huge percentage, ever since free agency, a huge percentage of the revenue has moved over to the players. I'm not sure that the existing players would favor getting rid of the antitrust exemption.
Such an anachronism.
Yeah, but hard to see that it's actually having much effect on the game itself. And the real question is how you maintain competitive balance, right? Mm-hmm. If you want to maintain the sport, the real question is how to maintain competitive balance. And without the antitrust exemption, it might be harder.
This is Bill Brown, retired partner and now of counsel at Phillips Lytle. I'm going to share with you my Bowie Kuhn episode. A former baseball commissioner, Bowie K. Kuhn, and a fellow lawyer, Harvey Myerson, who later became a guest of the federal government, formed the law firm of Myerson and Kuhn in 1988. Marine Midland Bank was its lender, and in 1989 the law firm began to fail. I handled the workout and subsequent bankruptcy of Myerson and Kuhn and the legal pursuit of Mr. Kuhn for the bank. The bank held full guarantees from Messrs. Kuhn and Myerson, and after efforts to successfully attempt to wind down the debt from the law firm's assets failed, following numerous meetings with Messrs. Myerson and Kuhn, the decision was taken to sue the two guarantors. We believe Mr. Kuhn was properly served by delivery of service of process at his law firm. Little did we know that Mr. Kuhn earlier that same day had purchased a ticket on Eastern Airlines to travel to Florida the next day, where he obtained his Florida driver's license and voter registration card in an effort to establish Florida residency, and homestead his newly purchased home in Marshall Landing, Florida, in an attempt to make it exempt from creditors. Mr. Kuhn subsequently challenged the appropriateness of the New York service of process, and he testified in a hearing on that matter before the Southern District of New York. The judge asked Mr. Kuhn if his name was still on the law firm door, which it was. The service of process was upheld. In the interim, we successfully attached his home in Quogue, which is in the Hamptons on Long Island, and then attempted to effect further service on him in a new action in Florida. And since he could not be found, we moved to also attach his newly purchased home in Marshall Landing, Florida. The basis, as I recall, was that Kuhn was properly served in New York before he became a Florida resident, so that the New York action was commenced, resulting in his inability to protect the Florida home through homestead. To defeat that attachment part of the Florida motion, under Florida law, Mr. Kuhn needed to come out in the open, and he appeared in a Florida court, which allowed us to successfully serve him with our new legal papers. Mr. Kuhn eventually paid his debt to Marine Midland, and we released the attachment on his Quogue home. In late 1993, Leslie Stahl of CBS's 60 Minutes did a 60-minute segment on rich people moving to Florida to avoid their creditors, which included an interview of Bowie Kuhn, where, after some questioning, Ms. Stahl asked about the purchase of the Marshall Landing home, which Kuhn called, quote, perfectly legitimate and legal, close quote. He went on to add, quote, nobody ever questioned the legality or propriety of what I did, close quote. Ms. Stahl then showed the Marine Midland complaint on camera, and she said, quote, yes, they did. When Kuhn split for Florida, the firm's biggest creditor accused him of fraud. Kuhn still bristles at the charge, since in the eventual settlement, he personally ended up paying more than $1 million of the law firm's debts, close quote. Thus, our episode with Bowie Kuhn ended successfully for Marine Midland Bank.